So it's no secret that I generally talk a lot about antitrust laws. I've interviewed 3 people so far about this. I interviewed Austin Yenne over in Iowa, a former House Congressional District candidate, and now a fellow over at Open Markets Institute about the agriculture concentration area and how that affects small farmers. I interviewed Vanessa B. from Current Affairs about her piece called The Rules of Monopoly, about her thoughts on what's become of our market and how that hurts consumers. And I talked to David Dayan, a freelance reporter, briefly about healthcare market concentration and how that drives up healthcare costs and how that's not really talked about enough. So I decided I'd reach out to Christopher Sagers, a distinguished professor of law over at Cleveland State University and also a senior fellow at American Antitrust Institute. I wanted to dive into the history of our antitrust laws and how they came about and why they were created and what's become of our market now and his views on this. He's written multiple books. He teaches classes on this, so I hope you enjoy. Thank you. So, you're currently a distinguished professor of law over at Cleveland State University. You've been there since the fall of 2002, and you've taught various courses from banking regulation to antitrust. With regards to antitrust, you've written many articles and books. What got you interested in antitrust law?
Well, when I was a younger person, I kind of found myself in law school a little bit by accident. It's a long story, but I had been a music major as an undergraduate, and you can't really get work there, and I couldn't think of what else to do. I wound up in law school, and to my complete surprise, I loved it. And given certain political leanings, I was pretty interested in business as a problem. In a certain sense, I thought of private power, accumulations of private power as a serious problem, and I wanted to think about something I could do or say in the world that would be relevant to that. And then I happened to take some economics classes, which was quite an eye-opener and a challenge for an old music major, and started to see the significance of antitrust and political economy more broadly.
Outside of teaching over at CSU, you also sit on an advisory board and are a senior fellow over at American Antitrust Institute. What do you do over there?
So the American Antitrust Institute advocates for more effective, more aggressive antitrust enforcement, and we do lots of things. We participate in litigation by way of amicus briefing. I've worked on a lot of that sort of work, and we provide a lot of policy guidance, a lot of policy advocacy to Congress and federal agencies. So kind of your basic think tank work. The single best thing about the American Antitrust Institute for me has been that its advisory board is about 120 of the absolute best thinkers in American antitrust, and not just from the left. I mean, it's ideologically diverse to some degree, and, in a lot of ways I wish that our internal listserv email list weren't confidential, because it's some of the best conversation on the hardest antitrust questions that I have access to.
I want to go back in history here and get up to present day. The first antitrust law was introduced in 1890 called the Sherman Act, followed by the Clayton Act and the Federal Commission Act in 1914. What made Congress pass these laws? What did these laws do?
Yeah, that's a good question. I mean, it's slightly more accurate to say that there had been antitrust and competition law even before 1890. All states had, as we say, common law rules concerning antitrust, meaning that the courts themselves posed rules without statutory authority that prevented certain kinds of anti-competitive conduct. But, around the time of the Civil War, American industry started to grow really, really significantly. The size of firms grew, and there was a lot of popular concern over that. Chief concerns included abuse of small entrepreneurs by large firms. Traditionally, we have thought, one of the major drivers of the adoption of the Sherman Act was the opposition of farmers, small farmers, particularly in the Midwest, to the power of railroads and agricultural distributors. But there was a more general concern with accumulations of power and the abuse of the weak, including consumers. And Congress acted in 1890, in part probably just because popular agitation had gotten so serious. There's a serious vein of historical scholarship in antitrust suggesting that the Congress of 1890 wasn't actually too crazy about heavily regulating business, but was quite concerned about the rising popular agitation and the need to do something. But another reason that Congress adopted a federal law, and I think this was widely accepted amongst the members of the 1890 Congress, was that state laws were necessarily limited in certain ways, and maybe the most important respects in which state laws were limited were that they didn't really provide penalties, either criminal or civil penalties for antitrust violations, and the federal law did. The federal law made antitrust violations crimes, and also state laws are necessarily, limited to the state's own jurisdiction. So, if New Jersey adopts a real tough antitrust law, well, all the corporations can just move their business to New York. So federalization was a pretty important thing, and driven by a lot of popular fear and animosity.
So what did the Sherman antitrust law do? The first one that was enacted.
Yeah, absolutely. all competitors, people who sell products in competition with each other, cannot get together and agree as to the price that they'll sell their product. There are certain other ways you can violate that rule, but generally speaking, you can't agree with your competitors not to compete. The second thing it did was that it made quote-unquote monopolization illegal, which is to say you can't get control over some whole market through nefarious means. That is, you can't get control over a market by doing things other than by competing on price and quality.
The Sherman Act was created in 1890, and then Congress decided to follow up again with another law in 1914 with the Clayton, and then creating the Federal Trade Commission Act. So what did the Clayton Act do that the Sherman Act wasn't doing?
Yeah, so it did a number of specific things. It was widely thought at the time that the Sherman Act had been ineffective. So the Sherman Act by then had been around for about 20 years. There had been Sherman Act prosecutions, not that many, but there had been some. And there had been some big ones, and in particular, there was a massive antitrust action brought by the federal government that generated a Supreme Court opinion against efforts to essentially monopolize all railroads. But for the most part, there hadn't really been that many antitrust actions, and many of them had failed. The federal courts were widely perceived as having resisted effective antitrust, having undermined the intent of Congress with respect to the antitrust laws. And in particular, there was a major lawsuit, again, a major federal lawsuit, another great big one brought by the federal government to break up the Standard Oil monopoly, sort of the biggest, baddest monopoly of the day, John Rockefeller's Standard Oil. And the government actually won that case, but the Supreme Court announced a standard for applying the Sherman Act in that case that many people thought had depleted the law of its power, had kind of emasculated the power, taken the teeth out of it. And in any case, business continued to just get bigger and bigger and bigger. In fact, the biggest consolidation of businesses in world history up until that point occurred after the Sherman Act was adopted. So between about 1895 and 1905, there was a massive consolidation of American businesses, and so people were still quite concerned. There was a sense that, we tried to stop this in 1890, the courts kind of messed it up, and business is still getting what they want. We got to do something. And so in the 1910s, antitrust was front and center. Sort of surprising that this would be the case nowadays. I mean, from our perspective, it seems a little surprising, but during the 1912 presidential election, antitrust was perhaps the key issue or one of the key issues, and all candidates in that election heavily campaigned on their position on the trust. So Woodrow Wilson wins. He has substantial support in Congress, and in 1914, the Clayton Act was adopted, which specifically identified certain kinds of conduct that many people thought the courts had failed to address under the Sherman Act. The Federal Trade Commission was created because, again, there was a sense that the courts had failed to apply the antitrust laws in the way that Congress intended. So Congress created an expert agency that was supposed to be independent, as we say. It was supposed to be politically insulated from both the president and Congress, and it was supposed to be an expert body that would understand industry and apply the law more scientifically. As the law has evolved ever since, really only one provision of the Clayton Act is still very significant in actual litigation, and that may be a good thing or a bad thing, I don't know. But as a practical matter, the only provision of the Clayton Act that's very significant now in terms of its actual substantive rules is that the Clayton Act said mergers and acquisitions specifically are illegal if they tend to reduce competition or create a monopoly. So, nominally, the Sherman Act could have stopped mergers, and occasionally the Sherman Act was used to challenge mergers over history, but it mostly was not a very effective challenge to mergers, and so Congress wanted to make a law that would be more effective. So as statutory antitrust law now exists, it consists basically of three rules. It is that first rule under the Sherman Act that you can't conspire with your competitors. The second rule under the Sherman Act, which is that you can't use illicit means to get a monopoly. And then the third rule is that rule from the Clayton Act that says mergers are illegal if they would tend to create a monopoly.
After 1914, in 1936, the Robinson-Patman Act was created, and then in 1950, we had the Seller-Kefauver Act passed in 1950. Right. Could you tell me what those laws added to antitrust?
Yeah, okay. All right, so a couple different things. I mean, these are very different laws. The Robinson-Patman Act is an additional antitrust law that grew out of the Great Depression. The Robinson-Patman Act and another statute that nobody talks about anymore called the Miller-Tydings Act were both designed to deal with the problem that retail stores in America, starting in like the 1920s or so, retail stores are starting to grow into chains, and the chains were getting real big. In particular, there was one chain store, the Amazon of its day certainly was the Great Atlantic and Pacific Tea Company, better known as A&P. And the Great A&P was a great big distributor of grocery products. products. But there were other chains too. There were other large grocery chains. There were also chain stores selling other products. And this had a lot of sectors of, American politics very concerned, particularly the smaller wholesalers and retailers, but also lots and lots of average folks were quite concerned that companies were getting so big and chains were taking over so much commerce. And this is all sort of familiar politics to us now because we've seen it happen again. The chain stores affected downtowns. They affected communities, find their own sense of place very much by the stores that were available on Main Street and so on. And obviously, too, there were concerns about labor opportunities and entrepreneurial opportunities. And again, these are all very familiar concerns from today's politics. So the Robinson-Patman Act and the Miller-Tydings Act, it's complicated, but basically those are laws that were meant to protect smaller wholesalers and smaller retailers from the buying power of the great big chain. The idea was the big chain stores could get big discounts from suppliers because they could buy in bulk. We can sell milk cheaper because we're buying so much. And the great A&P even sort of just integrated into its own supply functions. It actually produced some of its own agricultural products and did a lot of canning. Great A&P sort of pioneered the store label branded products. And the Robinson-Patman Act and the Miller-Tydings Act were both designed to prevent that. And to simplify quite a lot, both laws were meant to keep suppliers from giving very big chains unfair advantages over smaller retailers. So the Robinson-Patman Act is still the law. It's never been reversed. It's rarely enforced, though, and that's a whole complex story in and of itself. The Robinson-Patman Act has really fallen into disuse. The Miller-Tydings Act was actually repealed in the 1970s. So for better or worse, and some people think it's for the worst, the effort of antitrust law to keep suppliers from giving large distributors advantages. Antitrust has basically given up on that. We don't really do that anymore. The totally separate law that you asked about was the Seller-Kefauver Amendment, and this is important law. I think everyone would agree. And it was an effort to soup up that one provision from the Clayton Act that still persists, which is the rule on mergers and acquisitions. Again, you recall in 1914 when Congress added the Clayton Act, the thought was, well, the Sherman Act has been kind of underused, kind of misread by the courts, so we need a new statute to soup it up. And one of the things Congress adopted was a rule against anti-competitive mergers. Well, by 1950, when the Seller-Kefauver amendments were adopted, there was again a sense among much of the public and the antitrust agencies themselves that, again, the courts had sort of misused the Clayton Act. They had allowed companies to use loopholes to get through, the nooks and crannies of the Clayton Act and do mergers in ways that wouldn't be subject to the Clayton Act merger rule. So the Clayton Act, the Seller-Kefauver amendments tightened up those loopholes, right? Closed those loopholes. But perhaps more important than anything, Congress made very clear its intention that it wanted the Clayton Act to be enforced more aggressively against mergers than it had been. Indeed, Congress wanted the courts to stop mergers sooner rather than later, stop them, as we say, in their incipiency. So the Seller-Kefauver amendments emphasize that there is this incipiency standard that's supposed to be applied in our merger law. So don't wait until a monopoly has already arisen. Don't wait until there's clear evidence that some firm is getting a monopoly. Stop it before it starts. So, at least in principle, the Seller-Kefauver Amendment was supposed to make merger enforcement a lot more aggressive, and it was, actually. There was a period in our history from, I guess, the mid-1950s or so until the early 1970s, largely by the so-called Warren Court under Chief Justice Earl Warren. During that period, the courts applied our merger law and other antitrust laws very aggressively, and indeed, it was very difficult to have a merger that could pass muster under the law at that time. Since then, I think everybody knows the story in broad outline. Since about 1974 or so, the Supreme Court and the lower federal court have retreated again and have actually made it extremely difficult to enforce, particularly our merger law, but our other antitrust laws as well.
Actually, I was just about to get to that. So, history shows us that up until 1974, as you're saying, mergers were highly contested, like you said, by the Warren Court. And then it's commonly cited that Robert Bork, a failed Republican nominee of the Supreme Court, and the Chicago School of Economics substantially changed the way antitrust enforcement was viewed. So, could you explain to me, who is Robert Bork and what did he do, and where does the Chicago School of Economics come into play here?
Yeah, sure. Okay, so Bork was a Yale law professor who had studied in part at the University of Chicago, and he was, conservative in various respects, but he was influential in particular in a movement in economics. That larger movement is generally thought of as the Chicago School of Antitrust and the Chicago School of Economics. What is the Chicago School of Economics? Well, it's basically two things, I think. First, there is a commitment that the purpose of antitrust should be very clearly specified to include only a goal of of economic efficiency as defined by our economic theory. So that means antitrust is not supposed to serve other goals like preventing the concentration of businesses or the concentration of wealth to preserve political democracy. That shouldn't be a goal of antitrust. We also shouldn't use antitrust to protect small businesses for their own sake or to protect entrepreneurial freedom or anything like that. So it is now often said, and I don't actually like this very much. I think that the theoretical critiques are often confused and misunderstand a lot of things, but as a lot of people are saying now, the argument that Chicago made in this respect is that antitrust is supposed to serve only consumer welfare. So in other words, antitrust should really be focused only on making sure that products are produced efficiently, meaning that they're produced at low prices and that producers aren't able to use market power to extract value from consumers. That was point number one. Chicago said, look, we got to forget about all this political stuff that we've been talking about, small businesses for their own sake, antitrust shouldn't care about that anymore. And they made some good points. I mean, they pointed out, for one thing, that if you protect small businesses for their own sake, for example, that very well may be a desirable goal. It also might be something that you can find support for in the debates in Congress in 1890 or 1914. But a problem is that however great that might be, protecting small businesses for their own sake can be in conflict with other goals that we do care about. So, for example, there was a lot of law and policy agitation to thwart the Great Atlantic and Pacific Company. And, it was all very understandable because that big company was killing off local groceries and local pharmacists and other local businesses that were important to communities and so on. The problem is, before chain stores came, before chain groceries came, the logistics for distributing groceries were actually pretty poor. So, for example, prior to about 1910 or so, getting fresh food, getting fresh produce in particular, in cities was difficult. So like fresh fruit, fresh vegetables were very expensive and hard to come by in big cities until chain stores started to figure out ways to distribute this food more efficiently. So the tension that the Chicago critique identified is a real tension, whether or not they may have been ideologically motivated for their own reasons, and I definitely think they were. I think they were just sort of small government libertarians who hated law generally. But they did actually have kind of a good point. It's like certain values that antitrust had sometimes served were a little bit complex, more complex than we think of. And again, just as an example, improving the logistics of distribution is actually an important value. An expanding society actually really depends on. And if you prevent big business for just the sake of preventing big business, really is possible that you can kind of screw that stuff up. Okay, but anyway, so that's a tension that Chicago emphasized. Chicago harped on that goal, that idea excessively. They said, we absolutely must only care about one particular value, which is efficiency. Second thing Chicago pointed out was, in their view, you cannot simply look at a given market, identify that the market has a big firm in it, or that the market is concentrated in the sense that only a few big firms control the whole market, and then determine that there's something wrong in that market. Okay, so in other words, Chicago said you can't just look at the structure of the market and know that that market is not competitive. So that, again, posed problems for a lot of antitrust law, including, perhaps more than anything else, the merger law. So Chicago said you can't just look at a case and say that because a firm in the market is already big and it's trying to get even bigger through a merger, that therefore the merger will cause harm to the competition. But that was pretty much the opposite of what Congress seemed to say in both the Clayton Act itself in 1914 and in the Seller-Kefauver Amendment. Congress seemed to say quite clearly that it wanted court to look at the size of firms in a given industry, and when one firm was trying to buy another one and it would cause undue concentration, that should be held illegal. And the Supreme Court took that cue and applied that rule from the early 1960s until the early 1970s. But then it was sort of rejected on the basis of Chicago school arguments. So I rambled on a pretty long time about all that, but let me just say one last thing. There is a lot of talk about the Chicago school. It's almost a household phrase anymore, and it is taken for granted that the Chicago school, that is a set of ideas, was the real culprit in killing off our antitrust. That is importantly mistaken in one particular way. It was not ideas that killed antitrust. It was a change in antitrust institutions, and particularly the single most important institution in antitrust, which is the U.S. Supreme Court, specifically Richard Nixon. And again, this is like a real echo with current politics. A very conservative president made conservative appointments to the Supreme Court, and he happened to have sort of a historic number of appointments. Term in office, he was able to appoint 4, and those 4 justices who were all in place as a block and able to vote on actual cases by about 1973 or 1974. And they, in like just a couple of years, changed what had been the most pro-enforcement antitrust court in American history into the most anti-enforcement antitrust court in history. So, in other words, it wasn't ideas that were the basis of the change. It was a change in the courts. And that is a little frustrating to me because we are now in a position in which we've suddenly started to care about antitrust again, which in itself is great, but we're having lots and lots of debates about ideas in antitrust. And the claim seems to be that if we just figure out that rejecting the consumer welfare standard or something like that is the key to saving antitrust. The argument seems to be that if we just do that, then we'll have antitrust again. And the problem is that's completely hopeless. The ideas don't matter as long as the courts are sort of aligned against antitrust, and they will be till, either a Democratic president is back in office or Republican presidents can be convinced that antitrust matters and they can appoint lawyers who care about it. So in a way, the bitterest irony of the current debate over antitrust for me is that the debate we needed to have to save antitrust was not some angry sort of ideological sideshow after the election of 2016. The thing we needed to do to save antitrust was to elect any Democrat in 2016 because of the ages and terms of service of the sitting justices. It was clear that the president who got elected was going to repopulate the Supreme Court. And it looks like that's come true. Brett Kavanaugh seems still fairly likely to be justice, and he is by far and away the justice most opposed to antitrust, perhaps in American history.
So I want to back up for a minute here. We talked a lot about Chicago's school here. I've always heard that Robert Bork also had a large influence in this change of direction against changing that big is better. So where does Robert Bork come into play of all this?
Well, okay, so his most important significance in antitrust is 2 things. He wrote a book in 1976 called The Antitrust Paradox, and that book was indeed cited many times by lower courts and by the Supreme Court. He also wrote lots of law review articles that also were cited here and there, and then he himself was a judge of the Federal Court of Appeals for the D.C. Circuit, and he wrote some opinions in antitrust that were significant. So, he had an influence. He had an influence as much as any other particular participant in the Chicago school debate, if you will.
Okay, so I'm going to go ahead and fast forward here. In 2012, Libertarian presidential candidate Gary Johnson filed a suit under the Sherman Antitrust Act saying that the Democratic and the Republican parties, along with the Commission on Presidential Debates, have conspired to hold other parties out of the national presidential debates, basically the Green Party and obviously the Libertarian Party. As we know, the suit didn't get very far in court, but you actually wrote an article in Huffington Post expressing kind of disappointment. Could you explain what your reasoning behind that was?
Yeah, so my disappointment was not that the antitrust case didn't proceed. I think it's probably a good thing that antitrust does not regulate politics. That's why it was clear that lawsuit was going to get dismissed. Antitrust regulates the business. It doesn't regulate just any accumulation of power. So if somebody happens to accumulate a lot of power, I don't think it would be a good thing if somebody could bring an antitrust lawsuit to challenge the Democratic Party's use of superdelegates. For example, the superdelegates might be bad or whatever, but an antitrust lawsuit isn't the right way to address it, even if in some abstract sense you could say that the establishment Democrats, have a monopoly over politics or something like that. So I wasn't really disappointed that his suit didn't work. What I was disappointed by was that, you could sympathize with his frustration that we have a 2-party system and outside voices simply don't matter. His heart was in the right place.
So, in February 2013, you testified in front of Congress against the U.S. Airlines and the American Airlines merger. U.S. Airlines argued that even if they merged with American Airlines, that American Airlines would still only control less than 25% of the market and there would still be plenty of competition. What was your reasoning being against this merger?
Yeah, so airline competition, so they talk about their market share nationally, right? So if they say they have 25% of the market, what they're saying is that they have 25% of the national market for all flights, but that isn't a realistic way to think about airline competition or any kind of competition. Competition means the offering of products to the same consumers in competition with other people offering the same product to the same consumers. So competition in air travel, for example, means offering a flight from one city to another city to the set of consumers who actually want to fly on that flight. So competition, between a given pair of cities doesn't mean what are all the airlines who fly airplanes nationally. That's irrelevant to people who want to go from Boston to New York. What's relevant to those people is what airlines will fly me from Boston to New York on the days and times I want to go. So you have to think about airline competition in terms of each individual city pair all throughout the United States. Turns out there are about 4,000 city pair routes in the United States that the major airlines fly. Most of them are quite concentrated, and on significant sections of them, the American-U.S. Airways merger would give that merged firm a whole lot more than 25% of a given city pair. So the risk to competition wasn't air flight nationally. It was flights on individual city pairs in which the merged firm would have significant amounts of concentration. And if you can believe the government's complaint, there were about 1,000 specific city pair routes on which the merged firm would have really significant levels of concentration, like 40 or 50% of all the flights on those routes. I would think that's bad in any market, in any industry. But in airlines, there's a large amount of empirical economic research showing that when concentration increases on a given city pair route, prices go up. So to me, that's pretty cut and dry. It should be a clear violation of the Clayton Act merger rule, and it should be enough for the courts to say this merger is illegal. And I was very frustrated that the Justice Department settled that case, because I think had they gone through trial, they could have won, and it would have been a very important victory for antitrust.
So you say the Justice Department settled the case. What did they do to settle it?
So they did what they usually do, which is they agreed with the parties that the merger could go forward, but the parties would have to sell off some of their assets to third parties to preserve competition. So the idea is, if the merged firm would have a large market share between, say, Washington, D.C. and Charlotte, North Carolina, it would have to agree to sell its rights to serve that route to some other airline. So the government agreed with American Airlines that they would do, I think it was a package of divestitures like that, 140 or something specific routes had to be sold to other airlines. But it was a lot of divestitures. The government went on sort of a press blitz and tried to convince everybody that it was a really good settlement, and they claimed, that it was the largest single package of divestitures they had ever got in an airline merger. But that, I think, was all pretty misleading. It was the largest package of divestitures, but it was also the biggest, ugliest, most anti-competitive merger in the airlines ever. And the government itself said that there were another 900 or so routes on which the merger was going to limit competition. And indeed, there is some empirical evidence, some evidence by economists, that since that merger, prices for flights that the merged airline flies have gone up pretty significantly. So I think there was a substantial amount of consumer harm. The settlement was a slap on the wrist at best, and that was kind of a bad deal for us all.
In November of 2016, you wrote a paper or book, I don't know how you want to call it, Apple, Antitrust, and Iron.
That's right. That was a working title. Let me just say, that book actually isn't out yet. It's coming out this coming year in 2019 from Harvard University Press. That was a working title. It's now called The eBooks Case, United States versus Apple and Competition in America.
Oh, so what have I been reading?
You may have downloaded a paper that was the core that became that book later on. So that 90-page paper is now like a 500-page book.
Oh, okay. Because I was like, wait a minute. All right.
Yeah. It was on SSRN. Yeah, great. Okay.
So your paper in 2016 that you released, that was a prequel to your book that's coming out, was about the Justice Department's lawsuit against Apple and other trade publishing firms against alleged price fixing in ebooks. Could you explain to me what that lawsuit was exactly about?
Yeah, so I think it's the most interesting lawsuit to come along in a long time, because it raises a lot of these same very tense sort of political tensions that are at the heart of antitrust. Just like whether the rise of A&P, the rise of the Atlantic and Pacific, was a bad thing or a good thing. So what happened in this case was that the firms that publish books, trade books in English, which is to say basically fiction and nonfiction for general audiences, those firms, at the time there were 6 of them that dominated the market, they were very concerned that Amazon had recently introduced ebooks and was selling ebooks very cheaply. And the publishers were pretty worried about that for various reasons, and we can talk about why they were worried. And so the publishers, 5 out of the 6, agreed amongst themselves that they would no longer allow Amazon to sell ebooks at whatever retail price it wanted. And they set up a floor. They set a price floor for the retail price of their books when sold as ebooks. And they insisted that that price be the price on Amazon and on any other online platform that sells ebooks. They happened to set this conspiracy up with Apple, which at that time also was interested in entering the ebook market, mainly because at that time Apple happened to be introducing for the very first time the iPad. And the iPad was the first tablet computer. So, along with its introduction of this new product line, Apple wanted to say, hey, and by the way, you can also read ebooks on the iPad, and that was desirable because by then the Kindle, which was Amazon's ebook reader, was a very popular product, and ebooks were growing in popularity. According to the facts as found by the trial court, Apple instigated the conspiracy. It reached out to the trade publishers and suggested a program to wrest away the power of Amazon, and one thing led to another, and they had their deal. So the government sued and said that the agreement amongst the publishers themselves was a classic horizontal price fixing conspiracy. That is the most serious violation of federal antitrust law as it's currently constituted. And the government said that not only the publishers, who are one another's direct competitors, are liable under this agreement, but Apple is too. And that was so because even though Apple itself was not a direct competitor of any of the publishers, a person who sets up or coordinates or facilitates an illegal horizontal conspiracy is also liable for the conspiracy. So, to make a long story short, all the publishers settled with the government, took penalties, wound up paying some hundreds of millions of dollars to consumers, and Apple litigated the case through a full trial and on appeal, but it lost pretty much the whole way. So anyway, that's the Apple case. The reason I thought it was so interesting, and interesting enough to write a book about, was that basically to every antitrust lawyer, and most economists too, the case was a very easy case, slam dunk kind of case. If the government could prove the facts that it alleged, the government basically could not lose the case. And most antitrust lawyers and economists also agreed that that's a good result. Like, we shouldn't have horizontal price fixing conspiracies, and we shouldn't let companies like Apple set them up. But then to many, many other people, it did not seem like an easy case at all. And that was true of very smart, sophisticated people all across the political spectrum. And that was a big surprise to me when the case came out. I sort of thought we all kind of agreed that price fixing is not okay, and it's not even a good way, not a permissible way to deal with other competitive problems, if indeed Amazon and its low prices is a problem. So that seemed interesting. I thought, if it's true that there could be such a dichotomy between sort of the antitrust bar and the rest of the public about how we should face competitive problems, then that has to be an interesting story. So that's what my book is all about. The bottom line in the book, as you may know from looking at the paper, is we sort of say in America that we believe in competition. We believe in free enterprise, and that is embodied in our antitrust laws. I mean, if you have a competition policy, however you set it up, like even if you don't like our current antitrust laws for whatever reason, however you set it up, you're going to, in one way or another, attempt to sort of invoke the power of competition itself to serve your goals. Like, I agree that antitrust is a great tool, or could be a great tool, not only for protecting consumers, but also for preventing, undue concentrations of power and wealth inequality. But if I'm going to use antitrust to achieve those goals, that means I'm going to try to use the force of markets, the force of actual price competition itself, to achieve those goals. And in my mind, that was what Apple was all about. In other words, I should lay my cards on the table. I thought the government's antitrust suit in that case was a great case. I'm glad they brought it, and I'm glad they won, as I think they should have. Much popular opposition to the case. I didn't say this out loud. Maybe I should have. Much of the opposition to the case had to do with the fact that it seemed like the government was actually helping the real villain in the case, which is Amazon. Amazon's the real villain because it's this rapacious monopolist that's killing off the publishers and authors and so on. But I say, look, if you're going to have a competition policy, and it's actually a competition policy, I don't think you want to regulate the actual doing of business. What you want ultimately is to preserve circumstances under which markets themselves can regulate business. And that's what the case was about. Like, prices were doing what they're supposed to do. Amazon developed a cheaper product that consumers liked enough more that they would buy the ebook at $9.99 instead of a hardcover book at $35. And it's hard for me to see how that immediately is a real bad thing. It seems like a good thing. It seems like the same process by which the great A&P devised logistics that made food available to people at affordable prices and in healthy quality. So that in and of itself seems like a good thing. Most of the book is devoted to asking, are there other reasons that the case was a bad case, or that we should allow publishers to do what they did? And, as I sort of work through the various arguments, the point I hope to make is that, for the most part, the arguments that are made in a case like the United States versus Apple is that there's something about this particular market. There's something about, either the product or the nature of the market or changes that are going on in the market that make it special in some way, and therefore make it the sort of circumstance that shouldn't be governed by raw price competition. And so I say, fine, let's consider those arguments. But the point in considering those arguments is to say a couple of things. First of all, the arguments all wind up being arguments that, books are special, or e-commerce is special, or, technological change is significant in some special way. But I point out, look, first of all, every single one of these arguments, it turns out, is actually made in all kinds of cases. So the first time, American courts heard that price competition itself was the enemy and has to be stopped to preserve an industry, it wasn't in a seemingly special context like books. It was in 1896, and the product in question was cast iron sewer pipes. We were told that cast iron sewer pipes were so special that they can't be produced under competition, and without a horizontal price-fixing conspiracy among the manufacturers, very bad things will happen. So I sort of worked through the argument that books are special, or something else is special about the case, and I suggest these aren't new. They don't distinguish books from other products. Along the way, though, I say, look, there are some problems that are observed in this case. There are serious problems with the rise of Amazon and consequences that its rise poses for society in various kinds of ways. Some of them I think are exaggerated, like the publishers, for example, claimed that they absolutely had to have protection from Amazon or they would go out of business. And I say, look, if an antitrust defendant can say that they have to have a price-fixing conspiracy because without it they will go out of business, then antitrust shouldn't exist, because a fundamental goal of markets is to force businesses to be efficient, and if you can't compete on a cost basis with your competitors, you should fail. But even having said that, I also point out that the publishers are really exaggerating. The publishers have exaggerated throughout their history about the dangers to them of price competition, and we just don't have to worry about that so much, though even if we did, that's how markets work. Markets are painful. Okay, so I suggest that all these arguments, first of all, they don't really distinguish this case. Second, most of them are exaggerated, at least to some degree. And third, even to the extent that some of the arguments do contemplate some genuine pain, some genuine loss in society that we do actually feel, we have to make a decision at some point whether we're going to accept those kinds of losses, which we must do if we're going to have competitive markets, or whether we're just going to get rid of competitive markets. So at the very end of the book, I say, look, there are some concerns about the rise of a firm like Amazon or about the costs of, unrestrained capitalism that are real concerns that no moral society can ignore. But they aren't problems that we should address by reducing competition. They're problems that we need to address by other means. For example, the danger to Amazon's workers right now is a serious problem. Amazon's rise in its ability to pay its workers lower rates is a serious concern that people have talked about for a long time. I don't think that we should try to protect those workers by reducing competition for a variety of reasons. I think that we should have progressive tax policy, and we should have social and welfare spending, and we can afford to do that. So, in other words, my bottom line is I think that we should let competition do what it does well, and we should try to keep both the government and private restraints out of the way. But we should also recognize that there are costs to a system like ours that do actually have to be addressed, not only because it's moral to do so, but also because it's sort of central to having a competition policy. I mean, if you want to have a stable, long-term competition policy that has political viability, you have to protect people who are the losers in that system, and we should do it.
So we talk about Amazon's market power here. I want to talk about the dangers of Amazon just for a minute here, and I know we can go for hours on that. So Amazon is a market maker. It created a market, right? We can acknowledge Amazon created a market.
Wait. Created a market for what?
For product.
Okay.
So Amazon created a market for products. So it sells their own products. It has other companies join on to sell their products on Amazon. So now Amazon has created a market where they sell their products and they compete with other people to sell their products on their own market. So now it's also a shipper for those sellers. It's a lender to those sellers. It's a brick and mortar competitor to those sellers and other sellers. It's a data manager for those sellers and others. It's a search engine for those sellers, both online and digital assistants. It has the 4th largest brick and mortar bookstore already in the US. Amazon is on pace to have half of all e-commerce by 2021. It sounds like Amazon is a very large company. I mean, I haven't even hit the mark where it's got its own TV and movie studio.
Yeah. Big company.
So that sounds like that is a antitrust problem right there, that it holds all this power. What do you think about that? I mean, you mentioned in your book that
Yeah, my answer to that is easy. Sue them. If they've gotten their position in ways other than competing on the merit, sue them, because that ought to be illegal. In other words, in any of these cases in which suppliers to Amazon allege that they're being disadvantaged, or competitors to Amazon claim they're being disadvantaged, the solution is to have a real antitrust law that would allow suits against Amazon. I think that we could have an antitrust law of monopolization, an antitrust law of unilateral conduct, as we say, that is less obsessed with proof of actual real-world harm and less deferential to the defendants and less worried about the risk, to borrow a phrase that conservatives love, less worried about the risk of chilling pro-competitive conduct. And I think that we should enforce it. We should enforce that kind of rule more aggressively. So, again, I think the ebooks case is a classic perfect case to point this out. What drives me crazy about sort of the progressive left that is talking about antitrust a lot right now is that in a case like Apple and ebooks, what we should do is let the trade publishers agree. We should just let them do it, because that's the only way under our law they can protect themselves from, the monopolist Amazon. But I say it's a terrible idea. It's a terrible policy. It's proof that you guys aren't thinking about these things analytically. And the basic answer I say is don't sue neither of them. Sue both of them. If Amazon has gotten its power illicitly, sue it. But sue to stop these trade publishers from conspiring, because I think that many critics of the case allowed themselves to be snowed by these publishers who said, incidentally said the thing that they've been saying for a couple of centuries. And that is that they do what they do to protect authors. They do what they do to protect literature. And that is, that's laughable. The 5 defendants in that case were each massive subsidiary of the 5 conglomerates that control media in the world. In other words, they were each part of companies that each individually are bigger than Amazon. So if bigness is your problem, so sue them too. And moreover, if you think that they conspired to set the retail price of ebooks because they were trying to give more money to their authors, then I have a bridge to sell you in Brooklyn, because they weren't going to do that. No distributor in the history of capitalism has set up a conspiracy to benefit its own suppliers. They set these things up to benefit themselves. So I think that, while our antitrust has taken a pretty wrong turn, if we have an antitrust that just says, okay, well, a firm is really big, we have to sue them. Or a firm doesn't look like it's as big as somebody else in the market, so we have to let them do whatever they want, we're going to get cases really wrong, and we're going to have an economy that's even worse than the one that we've got.
So in your paper, right in the middle of it, you pretty much talk about how even when the Sherman antitrust law was created, these laws weren't popular, and they've lost popular support. So we've talked, and your point you make about Apple is that, Apple is this very popular company, and it seems like they're being taken on, and that this needs to become popular again and more mainstream. These things seem very complicated. How do you get this out there to the American people to actually be concerned and care about?
Yeah, this is an excellent question. I just let myself bash the progressive left a little bit, and thank you for indulging me in that. But the honest truth is that, within the progressive left, as I say, in antitrust, there are some very talented publicists, very talented people who are good at getting things on the popular agenda. And I say thank God for them. I'm frustrated with a lot of their ideas, and I think they get a lot of cases wrong. But man, they're really good at getting this back on the agenda. So, the answer to your question is, I wish I knew exactly how to do this better, because on the one hand, I can't sort of sit by and not say anything when I hear rhetoric in public that I think is going to have bad results. But on the other hand, that same rhetoric has made this policy much more popular and at least much more visible than it has been in a long time. And that popular support really is necessary if the agencies are going to bring the kind of enforcement that I want. So I guess my answer to your question is, we need to keep this on the front burner. We need to keep journalists writing about it all the time, and we need to keep popular concern with concentration and market power at the highest level we can. But we also have to remember, the cases have to be brought with a theoretical lens that actually helps us get the cases right.
I'd like to once again thank Christopher for taking time out of his busy schedule to talk to me about this subject. Clearly, as you heard, these laws were made for a very important reason, and the lack of enforcement has created a lot of problems in our market. I hope you found this as informative as I did. Thank you.